Thank you for joining me on today's webinar. My name is Sarah Smith. I'm an attorney here at Beresford Booth, where my practice focuses on estate planning and trust and probate administration. And today I'm going to be talking about who is in charge, as dictated by your will or trust or the relevant intestacy laws. Over the last few months, you've heard us talk about wills and trusts, the probate process, whether or not you need these documents. And essentially, you can kind of boil this down into looking at your documents as instructions. These are the instructions that are to be followed to manage your estate in the event of your death. But if we have instructions, then we have to have somebody who can actually follow and fulfill those instructions and do what needs to be done. Under your will, this would be the person that you nominate to be your personal representative. They would be the one in charge of going to the court, petitioning to be appointed as the personal representative, and beginning the probate process, which, as I'm sure you know by now, means loosely speaking, gathering all the assets, paying all the bills, distributing the remaining assets to the beneficiaries, dealing with tax returns, and then closing the estate. When you have a trust, either one that you have a living trust or a trust that you created under your will, a testamentary trust, then you'll have the trustee who is in charge of managing your assets and following those instructions. And one of the great things about wills and trusts is it allows you to choose who that person will be and choose who you think is responsible and has the skills necessary to fulfill these roles. However, if you don't have a trust or a will, somebody will still be appointed to fulfill the duties necessary to administer your estate. And that personal representative will be appointed by the court in accordance with the Intestacy Laws, which we'll get into in more detail in just a bit. But the first thing that I would like you to know about trustees and representatives is that, personal representatives, I should say, is that these are roles that are considered fiduciaries. Now, the Washington Court of Appeals has defined a fiduciary as a person who, on account of their relationship with another person, the beneficiary, is both authorized to act for the benefit of the beneficiary and owes a duty of loyalty to that beneficiary. So in a nutshell, fiduciary has a role or a service to perform and a duty of loyalty to another person while fulfilling that role or service. These duties, fiduciary duties, typically include the duty to administer the trust or estate in accordance with the terms of the trust or the will, honoring both the written documents and the intent of the trustor who executed the trust or the testator who executed the will. So we're honoring both the word and the spirit. There's also the duty of loyalty, administering the trust or the estate and managing the assets solely in the interest of the beneficiaries and avoiding self-dealing transactions, which is to say, avoiding acting in a way where you're putting, well, where the fiduciary are putting their benefit and their interest over that of the beneficiaries, or otherwise creating a conflict of interest. Perhaps it's not appointing themselves to a transaction that they shouldn't be a party to, but it might be their spouse or their friend. So this sounds a bit broad, and for a bit of clarity, let me give you two examples. Let's say we have a trust that allows for the sale of an asset, a piece of real estate, and the trustee wants to buy this real estate. Well, the trustee could, right? The sale is allowed by the trust, but the trustee would have to buy that property for fair market value and with the consent of the other beneficiaries to who they owe that duty of loyalty. They could not just swoop in and buy that real estate for less than fair market value or against the wishes of those beneficiaries. Conversely, let's say that same trustee is a CPA. While they could manage, those annual tax returns that must be filed themselves, they could not hire themselves or their firm and overpay for those tax returns. Yes, the tax returns must be filed, and doing so would not be a violation of their duties, but it's that overpayment. It's the prioritizing of their best interests over the best interests of the beneficiaries where we start to get into trouble. because the next duty that I want to discuss is the duty to exercise reasonable care and skill in fulfilling those duties. And the courts have found this to be the type of care, skill, and diligence that an ordinary, prudent person would use and exercise when completing similar tasks. An ordinary, prudent person is not going to overpay for a CPA or give away the house in a fire sale. Next, and unsurprisingly, is the duty to be impartial and fair, both in fulfilling the duties, but also in balancing the competing needs of the various beneficiaries. And this might sound a bit counterintuitive, but sometimes what this means is not treating everyone exactly the same, but being aware of and sensitive to the intent of the testate or the terms of the trust, and again, the competing needs that these beneficiaries may have. And the last one that I want to discuss is the duty to keep beneficiaries reasonably informed. And this requires that the trustee maintain records, accurate accounting of the assets they manage, and respond to the beneficiary's request for information in a reasonable period of time. So we have a whole list of duties that fiduciaries must comply with, in addition to whatever requirements are put in the trust or the will or other requirements that may be imposed by law. And these will apply to both personal representatives and trustees. So who can we appoint as the personal representative? How does that work? Personal representative is a person or entity appointed by the court to manage the decedent's estate until the estate is fully distributed and the probate is complete, that process that I touched on earlier. Now, you can nominate who you want that personal representative to be in your will. This allows you to choose the person that you want to uphold your instructions. But you have to note that the person that you nominate is not the acting personal representative until and unless appointed by the court as part of that probate process. And until they're appointed, they do not have the authority to act on behalf of the estate. When thinking about who you want to nominate as your personal representative, it's incredibly important to choose someone that you trust, but also someone who's able to handle the duties and responsibilities of that role. Remember that this is a job, and your personal representative will owe fiduciary duties to the beneficiaries of the estate. Also, it can be very tempting to want to pick your oldest child or someone for whom you have very fond feelings for. And often that is what happens. But those people may not feel comfortable taking on that responsibility or tackling those kinds of roles. So do think of it in terms of a job. That said, it's also a good idea to designate more than one person in case the person that you appoint initially, person A, is unable or unwilling to serve for any reason. They've moved, they don't have the bandwidth, perhaps they've passed on, then you want to have somebody in line B, C, D to be prepared to step up into that role if necessary. So you can appoint your personal representative, but there are a few limits. According to RCW 1136-110, any individual may serve as PR except minors, individuals who are under the age of 18, persons of unsound minds, and persons convicted of a felony or any crime involving moral turpitude. That is an act or behavior that gravely violates the sentiment or accepted standard of the community. And if not an individual, if there isn't someone that you choose to appoint, certain businesses such as trust companies could also be appointed to serve. Forgive me. Trust companies can serve a couple of very important benefits. They're going to come to play with experience and skills and just be that independent actor that you might need, particularly if you don't have individuals who would want to serve in these roles. Second, even if you appoint somebody, the surviving spouse is always going to have the right to administer the community property of the deceased spouse's estate as personal representative, even if the deceased spouse's will says otherwise. So if you draft your will and appoint person A to administer the estate, the surviving spouse has 40 days to petition to be appointed as the personal representative of the community asset, the community property assets specifically. The surviving spouse, however, can waive that right either in writing, or it will be presumed to be waived if they do not petition for appointment within 40 days following the death of their spouse. So we've discussed your ability to nominate a personal representative under your will and some considerations for who you might appoint and how that works. But what happens if there is no will? Or perhaps for whatever reason, the individuals that you nominated are unable or unwilling to serve and there's a vacancy in the role. When that happens, then the court will appoint an administrator to administer the estate and essentially fulfill those roles and duties that a personal representative would in managing the estate. In accordance with RCW 1128-120, the individuals who would serve in the following order would be first the surviving spouse or registered domestic partner, or the individuals that they might designate. And if not, then the children of the decedent. If not, then the parents, siblings, grandchildren, nieces and nephews, trustee named under a trust, whether living or testamentary, and on and on and on down the list, potentially even including a creditor of the estate if there's no one else willing to serve. And the idea is just to try and go down, and again, as you may remember from the last webinar, who would a reasonable person want to serve that role if none have been appointed? And just trying to make the best decision that the court can. That said, if ultimately all else fails and no one can be appointed, then the court has a service provider that they can appoint in that stead. So that covers wills. What about trusts? So as you may or may not know, a trust involves three parties: the grantor, or the person who creates and executes the trust; the trustee, this is the person or persons who manage the trust assets and have legal title of the assets and handle everything on behalf of the beneficiaries. And then, of course, the beneficiaries who have the equitable title of the assets and benefit from the trust. So you can essentially designate and appoint your trustee or trustees under the trust. However, they don't really become the trustee and step into that fiduciary role until after they accept the responsibility of acting as a trustee. So you can appoint person A to be the trustee under your trust, but they have the ability to recuse themselves and say no thank you. This is why it's important to make sure that you're checking in with the people that you want to appoint, either under this or any of your other roles, in fact, and make sure that they're willing to serve. And as the years progress, you've heard me talk about checking in every few years to make sure your documents still time. They've moved, they no longer have the bandwidth, etc. Because if not, in accordance with the law, but also as dictated by the terms of the trust. So remember, we said earlier, these are duties of loyalty, acting in good faith and good care, etc. And again, like with the personal representative, this is a job and could in fact run for years, if not decades. Not that they can't, again, step down in accordance with the terms of the trust, but this is a job, and the people that you designate should be prepared to deal with that job, having the skills necessary and the ability to handle that responsibility. So another consideration I'd like to mention, given again the longevity that a trust might have, is not just the idea of naming your initial trustee and successor trustees, which is always a good idea, but also what happens if there is that failure. Who would you consider, or who would you want to be able to appoint additional trustees? All the beneficiaries? Would they have to act in concert? Should the last serving trustee have the power to appoint additional successor trustees? And if we've given someone the ability to appoint a trustee, someone other than the grantor, who? Anybody? Only somebody who is a fiduciary, professional fiduciary, like a CPA or a trust company, or perhaps anybody, but they must be appointed with such a professional fiduciary. What kind of flexibility do you want to allow? Because ultimately, if there is a failure or a vacancy of the trustee, and there's no terms in your trust to provide for additional persons being appointed, then the vacancy will essentially require a non-judicial binding agreement or a judicial petition to appoint a successor trustee. And I suspect your beneficiaries will appreciate avoiding the expense and hassle of dealing with that process. So we discussed personal representatives and trustees, both the processes of appointing them actively and what happens when there is no will or a vacancy under your will or your trust. So now a couple of practical considerations, and some of this probably sounds familiar. When you come in to work with your attorney to do your estate plan, whether you're thinking about trusts or wills or both, you don't have to have everything figured out, but it's very helpful to start thinking about these issues and thinking about those things which are important to you and who you do trust, and who you trust to have the responsibility and the skill and the dedication to deal with the roles that you're asking. Not that these people have to act independently or necessarily even should act independently. Personal representatives and trustees will often act with a team of persons, including an attorney, CPA, financial planners. But even so, it is a role and there are duties associated with that. And some people just don't like numbers. In addition, while thinking about that, it's very common to appoint a person or persons, family, friends, etc. But there is that option of using a professional fiduciary, a trust company, or some other organization that really focuses on this kind of work. There are expenses associated with that, as I'm sure is no surprise, but this can take the pressure off of your family from providing those roles if no one is willing and comfortable doing so. It can also provide objective, skilled individuals who are able to act if perhaps you don't feel that your immediate friends and family should be given that role for whatever reason. You're concerned about conflict, you're concerned about their ability to handle the role. Maybe there are creditor issues to consider, or the only people that you can think of are out of country, and appointing an individual who is not a US citizen can provide its own complications and expenses. And in addition to the option of this professional fiduciary, do you want to appoint one person and then a successor singular person? Or do you want to perhaps consider multiple co-personal representatives or co-trustees? Generally speaking, the more people you have, it's kind of like having more cooks in the kitchen. It can increase complexity, increase an opportunity for conflict, but it might be, under certain situations, that having two people working in concert can provide benefit, can provide oversight, and may serve a role in your estate plan. It's worth the conversation if you have concerns about specific people. And finally, it's not uncommon for me to have people come in and express that there are certain people that they're interested in, who are willing and able and skilled and responsible, but perhaps they're older, or there's concerns that they won't be around or able in 20, 30, 40 years. But that's fine. What you have to think about when considering these roles is really not the person who you expect to be there in 30 years or 50 years, but even just the person that you expect to be there in 5 years or 10. Because ultimately, these are living documents, wills and trusts. These are all things that generally, usually, can be updated and should be updated as time progresses and circumstances change. Now, this is not always the case, right? You can't change a will after the decedent has died. Trust can be drafted in a way that's irrevocable. But very often, and for many people, these are documents that can be changed over time and should. So don't be overwhelmed by this idea of such and such person is of a certain age. There's not necessarily a problem. Focus more on who's best to serve that role, and come with questions, concerns, thoughts. This is a conversation between you and your estate planning attorney. Just taking a glance to see if there are any questions. So far, it doesn't look like it. I think that's about all I have for you folks. Unless there are any questions, I'll just give you a moment. No? Okay. Well, thank you so much for spending part of your day with me. Again, my name is Sarah Smith. I'm an attorney here at Beresford Booth, and thank you so much. Have a great afternoon.